A great deal of farmland is held in joint tenancy between husband and wife. But how much of jointly held property is included in the tenant's estate at death? Well, this is an important issue in the present estate planning environment. And joining us now to discuss is Roger McEowen. He's with the Washburn University School of Law. And Roger, as always, thanks for taking the time to chat with us about another important issue. First of all, start by distinguishing the characteristics of joint tenancy.
Well, joint tenancy is characteristically known by the survivorship feature. So if a person has a deed that indicates that, for example, husband and wife own the farmland as joint tenants with rights of survivorship, then you have the key language in the deed that creates the joint tenancy feature. It's that right of survivorship language that is absolutely critical. Anything less, and you don't have a joint tenancy. Now, the key feature, what that means is that upon death of one of those joint tenants, let's say it's mom and dad that owns the farmland or the ranch land in joint tenancy with right of survivorship, when the first of them dies, their will does not control passage of their undivided one-half interest in that land. It's going to be controlled by the survivorship feature. So if the surviving spouse is the designated survivor, and they would be because of that's the way that my example I set up the deed language, then regardless of what the first spouse's will says, the survivor has the entire ranch land. And that's different from a tenancy in common, which is controlled by the person's will.
Interesting. And how is the property tax for joint tenancies involving persons other than the husband and wife?
Well, see, this is a big deal because now, not with the new tax law, we not only got a tremendous increase in the exemption from federal estate tax, up over $11 million per decedent, but we got stepped-up basis retained. So we have both the best of both worlds in that situation. So a lot of what we want to do from a planning standpoint is cause inclusion of property in the gross estate because that exemption's high enough for the vast majority of farmers and ranchers that there won't be estate tax. If it's a joint tenancy that is owned between spouses, the rule is that automatically one-half of the date-of-death value of the entire tract is included in the first spouse's estate, and so the surviving spouse would only get a one-half basis step up. But if we've got some old joint tenancies on farmland that are out there that were created before 1977, and now we've by married couples, and now we've got the spouse that provided the funds to buy the property that has died, that surviving spouse can get a complete 100% basis step up, cause all that property to be included in the estate, probably no estate tax because the exemption's high enough to cover it, and the surviving spouse will get a full basis step up and then could sell the property at no gain.
Roger, whenever you take all of this into consideration, what does all of this mean? What's the big takeaway?
Well, the big takeaway on this is to go out and see if a listener happens to have one of these old marital joint tenancies, a pre-77 joint tenancy, and if the spouse that provided the funds to acquire the property has now passed away or will soon pass away, the chance for that surviving spouse to get a full basis step up and then no capital gain tax on sale, that rule can still apply. And there still are some of those out there in agriculture.
All right. Well, Roger, as always, thank you very much for your insight. Roger McEowen with the Washburn University School of Law on the phone with us today from Iowa.